Thank you, everyone, and welcome to another episode of Circle City Conversations. I want to thank everyone for listening in and joining us today. I want to thank our sponsor, Hearst Lamontes, an Indiana law firm that continues to do excellent work for their clients. I'm here with a wonderful trial lawyer, attorney Katherine Karres of Hearst Lamontes. Katie, thanks for being here.
Thanks for having me.
And Katie is going to be helping me kick off a new series here at Circle City Conversations called Litigation Lessons, where we discuss and, more importantly, dissect some of these cases and legal situations, both good and bad, because obviously an experienced trial lawyer has lost cases, right?
Yes, if anyone tells you they've never lost a case, it's probably because they've never tried one either.
Right. So this episode is going to focus on a case that you tried up in Fulton County, Indiana.
Correct.
And Fulton County is a population, I looked it up, of 20,327 people.
Oh, the whole county, yeah. That's not surprising at all.
Yeah, so small town Indiana. And
almost all of them knew my defendant.
Yeah, and so the county seat is Rochester. And I have a couple friends, actually, that have, there's a lake up there called Lake Manitou. I don't know, I'm saying it. But it really is a beautiful but small place. And like a lot of more rural type counties in Indiana. So tell me just a little bit about this case that you tried up in Fulton County.
So it was a trip and fall at a landlord tenant. So the tenant had lived at this very small, I don't even know if I could call it an apartment complex. It's just a couple rows of buildings that had about 4 apartments in them. It was very, very small, right off of 31. And she had lived there for many, many years. And the landlord had let the sidewalk area in front of her small apartment go into disrepair. And she had had some problems with it and actually had fallen and injured herself twice. And the first time she fell, it was a minor injury. And then the second time she fell, she broke her wrist. And so we had this claim ultimately that went to trial on her second fall, even though the jury didn't know exactly what had happened to her as far as the specific injury.
Let's talk a little bit about trip and fall cases, especially here in Indiana. My understanding is that statistically, usually less than half even actually see a verdict. Is that right?
Oh, yes. It is very difficult to try slip and fall or trip and fall cases in Indiana. A lot do get disposed of by summary judgment. Yeah. And just because of the claim for fault on the plaintiff, the whole you should have been looking where you were going, when, of course, as we know, it's not always that simple.
Right. And you said something that was interesting because we talked about this yesterday on another case, or maybe the day last week, but the case is getting disposed of on summary judgment. Tell me a little bit more about that. What is that?
Which is essentially when the defendant, which in this case would have been the landlord, asked the judge to get rid of the case on the legal technicalities alone. Basically, doesn't ever get to see a jury. So sometimes clients feel that, well, if the jury just hears about my case and hears my facts and my story, they'll fine for me. Well, a lot of times the law in Indiana offers some protections to defendants, in this case, such as landlords, and they will file for the court based upon the law in Indiana to dismiss the case.
So potentially a defendant could get out of the case without even having to put that case in front of a jury?
Correct.
And so you've been practicing now, we just talked about it, 17 years, right?
Yeah, coming up 17 years in October.
And you and I, we've been practicing the same amount of time. You have more trial experience than I do. Have you seen recently an increase in these motions to dismiss and things like this being filed in trip and fall, slip and fall type cases?
I'm not sure that I have personally seen an increase. I think I've handled so many of these cases over the years that I feel that I always see it. I've always seen a lot of motions for summary judgments, motions to dismiss. So I feel like I've always seen it, but it's possible other lawyers are seeing an increase in it. But I'm definitely, I always expect it. And maybe because as I've gotten more seasoned in my practice because I know what to expect, that I can advise clients to make sure they're always telling the truth, but they don't get into the traps that the defense try to set for them so that they can set them up for dismissal. Now, of course, the facts are the facts and you have to tell the truth. But if you can make sure that your clients don't fall into the defense attorney questioning traps in their deposition, sometimes you can protect against that.
That was really clever. Fall into the trap.
That's what they are. That's what they are. I feel like that we could have 5 other podcasts on that, but that's how I feel a lot of the questions end up in depositions for your clients is they're sometimes, they feel like they try to set traps for them.
Right. And you don't, I've never known you to shy away from really anything, but you don't.
Truer words were never spoken.
You don't shy away from these types of cases, even though statistically you could potentially lose them.
Oh, I really like premises cases. I mean, as you know, probably over half my practice is somehow premises related, whether it's a traditional fall down at a landlord tenant or at a store, or I do schoolwork, and a lot of that is premises related. My children child was on your premises and you did not keep my child safe, or my nursing home work. A lot of those are fall downs too. My elderly family member was in your care at the nursing home on your premises and you didn't keep them safe. Now the law that applies is different. But I really enjoy these types of cases, and I don't want to give away too many secrets, but I feel like you can have success as long as you can prove 1 or 2 bad facts for the defendant. So it's not a scorched earth approach. You've got to find out what your theme is, and you've got to find out where the failure was. And that's really just 1 or 2 facts, and that will make the case.
When it comes to premises cases, is it fair to say that, proving notice for the defendant, like the defendant knew of whatever that issue was, how important is that?
Oh, it's extremely important. And it's not just the know, right. It's knew or should have known, as we know. So, I mean, they either need to know or you have to prove that they should have known and had a blind eye. Right. They turned a blind eye to the issue. And if they had been paying attention or if they would have realized it was there. So in our case, the landlord can't say, well, we didn't know it was in disrepair. Well, if you ever went on the premises and laid your eyeballs on this sidewalk that you were making all this money from, and that was really our theme, is this landlord kind of acted like he didn't know it looked so bad. Well, that's because you just take the money and you never actually go physically yourself onto the premises and look to make sure the business that you're getting money from is in good repair. And so those are important things. You knew that it was a problem, or you at least should have known. So that's a lot of where, we have to come into play is the should have known, because a lot of landlords or any owners are not going to admit that they knew that they had a hazardous condition on their premises. I don't think I've had anybody ever really admit to it unless they say, well, it was so bad, it was obvious and you should have realized it. But that's never really a good defense. But, it's more along the lines of we have to prove that they should have known. And why should they have known? They probably should have paid better attention. Yeah.
So, and for example, like, let's say in big box store type cases, you've got employees walking around. And if they were watching, they should have. Yeah,
if they were following their protocols, if they were walking around, if they were doing their sweeps of their aisles like they were supposed to, which is usually every 30 minutes to an hour. If they were looking around like they were supposed to, they would have seen that something spilled on the floor, or something of the nature. So, but that's how we just get into those policies and we start looking at those surveillance videos. We didn't have any of this here because it was an apartment, but that's how we work on those big box store cases.
So let's go back to your case and let's kind of talk about in this particular case. These cases you can split them up and at their simplest to liability and damages, right?
Correct.
And you did something which is called bifurcation. Okay. Normally we would try a case and try both liability and damages together. However, in this case, you bifurcated, which means, well, why don't you just kind of explain to me, tell me what you did?
Bifurcation is just a fancy way of saying we separated the case into two parts. And so you can bifurcate it and just do the liability side and leave the damages out. I don't see how you would bifurcate and just do the damages unless you had already done the liability. But normally in these cases, if you bifurcate them and you separate it and you just do the liability side, if you win, which obviously in this case we did win, which is why we're talking about it, they usually do resolve because the biggest argument is the fault.
Yeah.
You don't even get to the damages side as far as what does the client deserve for their injuries because you never get to that part because the defense doesn't believe you're going to win on the liability side, which is in our state, you have to prove at least 50% liability on the defendant. It's got to be 50-50 for you to win. And in my case, the defense didn't feel that we were going to be able to get the jury to find 50%.
So in your case, the defendant agreed because they thought that if they tried the case on liability, they would get more than 50% fault on the plaintiff.
Yeah, and in fact, they felt like they were going to get 100% fault on the plaintiff. So that is a possibility in our state to get a verdict form where they find that the defendant didn't do anything wrong.
Yeah.
And that there's no fault on the defendant. And that's what they urged is that the jury find that they didn't do anything wrong and not even to split the fault, just to give no fault to them. So there's no liability. Obviously, the jury found that they were 80% fault in this case, and my client was 20% at fault. Okay.
We'll talk a little bit more about that later. Let's talk about maybe some of the other advantages of bifurcating a case, length of time, costs.
Yes, absolutely. So as a plaintiff, if it's something that you're willing to do, there are multiple positive effects to it. One is that you can usually get into the trial sooner.
Oh, yeah. Yeah.
Because you're usually only taking up 1 day. So let's say a traditional case will take 2 to 3 days to try. If that's really the case here, then your trial is likely just going to take 1 day. And so it's really a lot easier for the judge in the court to set on his or her calendar 1 day aside versus 2 or 3 days, which is, might as well be a week, you know? Now, if your trial is supposed to be 4 or 5 days, maybe it takes 2 days to do a liability-only trial. So I find that you get in sooner. So that's the first thing. I find that also I believed, and we had a lot of strikes for cause on our case, but it's easier to find a jury that's going to be more fair because they don't have to make a decision about money for pain or money for damages, because if you've tried enough cases, you know that
you have to voir dire on that too.
The biggest, so it's an easier jury selection because you don't have to talk about liability and damages, because a lot of people struggle with giving money for pain and money for damages because they just they feel like there should be a formula or a magic number, and if not, then they just don't know what to do with it. And so in our case, in any case that's bifurcated, they don't really know what the injuries are. They don't know what the medical expenses are, and they're never going to be asked to give anybody any money, and they don't feel responsible for giving money, and they don't feel guilty about giving a money verdict against the defendant. And so all they are asked is you just decide who's at fault. Yeah. It's almost like, a fight between your children. You just decide who's responsible and not a punishment, I guess. Yeah. And so that made jury selection a little more streamlined. We had complicating factors just being in the small county, but you really get to streamline your jury selection on liability only, which of course has its own challenges in fall down cases because a lot of people have that thought that if you fall, then you automatically have some fault. And that does, if they can't set that aside, that is a strike for cause. And that's one of the reasons why we had so many strikes for cause. Yeah, but because of the fact that you bifurcated it, you can really hone in on that bias that people have about if you fall, like for example, we focus grouped ICE cases. Mm-hmm. They're so hard in Indiana.
And a lot of Hoosiers believe you fall on ice in Indiana, that's on you.
Yeah.
Yeah.
Yeah. And so I was able to focus really on the potential bias, and I wasn't distracted on those people that struggle with money for pain or money damages. I really focused on that, and we spent a lot of time talking about that, and therefore the jurors that really should have been struck for cause because they weren't the right jurors for the case, and that's what the jury rules say. I was able to get those off for cause rather than using my very, very limited peremptory challenges, which are the challenges I could use just because I don't feel like having them on my jury. The strikes for cause are the law says you are not appropriate for this case and the judge must relieve you and you don't get to sit on this jury.
Yeah. Essentially, that person has some kind of bias or prejudice. They just can't set it aside. Right?
Correct. And therefore, they would just, not that they're a bad juror or a bad person, they're just not right for this case.
Exactly. And, it's so funny. That's, I know you love jury selection. You love work.
I really do. A lot of people don't like it. And I think, trial by fire, I guess. I've tried so many cases, especially early on in my career, that, I was forced to do jury selection. I took a lot of seminars on it because it is so nerve-wracking. You're in front of people, and you never know what verbal bombs are going to come out of people's mouths in jury selection. I actually have learned in my career to embrace that and embrace what people say, because I have found that if they don't say it, they're thinking it.
Yeah.
And if they're thinking it and they end up on your jury, then that's going to be reflected in your jury verdict. So I'd much rather them say it. I get it out in the open. I find out who does or does not agree with them. And they either get struck for cause by the judge or I get them off. And then I figure out who else maybe needs to go too because of their internal bias that makes them not right for the case. So I welcome just whatever anyone has to say about anything. I completely welcome it. I do not shy away from it. I do not ignore it. I do not sweep it under the rug. Just bring it out. I want to hear it now because I'd rather hear it in front of my face when I have a chance to address it and figure out if it's, a correct view or not. If it's something that's not the correct view of the law, rather than it happening behind the closed doors in jury selection in jury deliberation, and it affects my client.
Yeah, exactly. Because, if you don't address it when it's out in the open, you could potentially wind up with those people on your jury.
Correct.
Yeah.
And the verdict just plummets.
Yes. Yeah. And in a trip and fall case, you could potentially get more than 50% fall.
Correct. And then you lose.
And you lose. Yeah. So strikes for cause. I had a judge tell me once, he said, "Counselor, I don't think that there is such a thing as strikes for cause in the state of Indiana."
well, I've in trying my cases, I have definitely proven that wrong. Years ago, I think it was in 2016 or 15, I took a seminar from Keith Mitnick, as we know. He travels around, and it was either all about or primarily about jury selection. Yeah. And I still, remember him and remember that voice he has. And he went through the jury rules, our Indiana jury rule, and how to set it up if there is somebody that you believe is going to be a strike for cause. And I have had, I think I had the next trial that I tried after that. I believe, and my memory could be incorrect because it was 8 years ago. I believe I got 13 strikes for cause.
Yeah.
And sometimes you get them because people start following, but if that's what they say and they say they can't set aside, you can't help that. That's what people have said. But in that case I did. And, we got a pretty good verdict, all things considered, in that case. And in this case, we got 8 off for cause. I do think a couple of those were because they knew the defendant, but I know I had, we got 8 off for cause. So
suing a local businessman in small town Indiana, where a lot of people know that person, and I've done this before. Bill and I did it in 2015, and the jury came back after 22 minutes with 100% fault on our client. So, I know it's hard. So
I have been there. I have been in a small town years ago. I want to say 10, 12 years ago, I tried a case in a very small county, and it was against a local hotel.
Yeah.
It probably was very well liked, and we got no fault on the local hotel, and I think that hotel was probably really well liked.
Yeah.
In this case, it went the other way.
Yeah.
And there's many potential reasons for it. The jury did not talk to us after the trial, so I don't really know. I think that sometimes, especially in our times now, there's becoming a widening, a V between the haves and the have-nots.
Oh, yeah.
And I feel that our landlord was a have.
Yep.
And he was renting to a have-not. Mm-hmm. And he wasn't repairing it. And he wasn't taking care of it. And he wasn't coming by it. And he wasn't giving it very much attention. And it was very clear during jury selection that he was a man of means.
Yeah.
And ability to take care of it.
Yeah.
And my jury, and it was 8 strikes for cause plus 3 gentlemen who were businessmen who knew him. And because they had known him, they got struck because you can't, be close enough and really know a party. We ended up with 6 women who lived just regular lives in that county. They just were a regular citizen of that county. They weren't necessarily probably big on the have and maybe not a have not. I really don't know, but they were not, very, very successful business owners. And they probably looked at that person like, you could have done better.
Yeah. So how many people did you have left in your jury pool once you got done with?
Well, essentially in the negative, really, because you traditionally, when you try a case, you'll have your 6 jurors plus at least 1 alternate.
Yep.
And we have an alternate as a safeguard.
Yeah.
Okay. If it goes, to the next day and somebody gets sick or you never know what happened, they don't show back up. Then you have that alternate comes in and takes your 6th juror. In this case, after everybody was struck and we had a couple people who weren't eligible to serve for various reasons, we only had 6. We had our 6 jurors and we had no alternate. And you can agree to that. Both plaintiff and defendant have to agree to a jury of 6 with no alternate that if something happens, I guess, at the lunch break, because we knew it was one day, that it would be a verdict of 5 if something happens to one of them. And we agreed to it because we thought we were unlikely to lose a juror during the day.
Yeah.
But there was no one left for an alternate. I mean, in part because it is difficult for the courts to get people to come in for jury service. Yeah. They send out, small counties like this might send out, Marion County is different, of course, but they might send out 45 jury summons and, 25 show up. So in that case, between our peremptory, which you can choose your own strikes for both sides, plus the strikes for cause, plus the people who were ineligible to serve, plus the 3 people that knew the defendant, it was 6 plus no alternate. But it was fine. Everybody was able to hold on for the 8-hour day. They're 9 hour ended up, I think, probably about 9 hours after we got the jury verdict. So, no extras.
How long did jury selection take?
Oh, I want to say jury selection took most of the morning. I don't remember the exact time, but it's certainly more than 2 hours.
And the judge, no time limits or anything from the judge, or
he didn't place any time limits on us specifically. This was his first civil trial. Okay. In counties, most counties, not every county, and it's the judges hear both criminal and civil. So he's had smaller counties where they have just a general docket.
Yeah.
In Marion County, you're not going to see that, and maybe most of the donut counties, you're probably not going to see it either. But this was his first civil trial, so he was used to strikes for cause.
Yeah.
He was used to jury selection taking a little bit longer because in those criminal cases, it's obviously very, very important because it's not just someone's money, it's someone's liberty.
Right.
So it took us most of the morning, I would say.
Yeah.
And he didn't put any limits on it, which was nice. But I'm the kind that I'm only going to ask as long as I need to.
Yeah, yeah.
So not everyone's like that. Some people like it short. Some people will use as much time as possible. For me, it's like nobody really wants you to be standing up there long-winded in any part of the trial. So I tried to be as speedy, judicious as possible. in all areas of my trial. So since we were moving along, we had so many different strikes for cause, and then so we'd have to go up and get them struck and then bring more people in to our box of 14. That did take some time. Yeah.
And when you do that, for people that haven't tried a case or been in a situation like that, you're basically sitting up there with the judge right up at the bench, kind of whispering.
Yes, and for me, I'm usually on my tiptoes since I can usually not see over. They have to bend. Booster? I need a step stool.
A step stool.
I normally am on my very tiptoes and telling them they all have to bend over because otherwise, like, I'm not part of the conversation.
You should have brought your own step stool. That would have been awesome.
Next time, maybe it'll give me more sympathy from the jury if I have to approach the bench and carry my own step stool. With me. We've talked about that because I can stand closer to the jury than you can because there's over a foot height difference between you and I, and nobody finds me to be, I guess, encroaching.
I've been told at trial, I've essentially been told to back off because I'm so big that like I can seem like I'm trying to intimidate the person, which I can't remember who it was. Maybe I was actually trying to intimidate them, but obviously that's never a good look for a lawyer,
For me, when they're sitting, especially the people in the back row, because they're a little elevated, they're practically at eye level with me. Right. So it's never been a thing. I mean, I don't ever like to get in anybody's space, but I don't have that. I don't think I present that feeling. Yeah. So this case, let's kind of talk about the process a little bit. Sounds like you did jury selection for a few hours. Did you break for lunch then, right? I think we were able to have like one or two short witnesses. Oh, we had a couple. We had a couple short fact witnesses that had come in, essentially other friends, visitors of my client, and people who had lived in the apartment complex. Some people still live there, to say, hey, this has been like this for a long time. Okay. And he knows. Yeah. And we complain. And we have a hard time even walking in that area in front of your client's home and her door because the sidewalk is in such disrepair. Yeah. How did our client? She did pretty good. Yeah. She did pretty good, all things considered. Maybe not ideal, but honestly, I don't know that the juries anymore expect perfection. Yeah. She was just a regular lady. Yeah. She was just a regular lady, and she told the truth, and she was honest about it. Yeah. And I think sometimes when you have that, and the jury can see like someone maybe is not super sophisticated. Yeah. And then they get maybe picked on a little bit by the defense attorney, kind of try to set a trap in jury. Yeah. And during the jury trial, I think that's maybe what the jury saw. Yeah. My client was a female, and the jury was all female. Uh-huh. The defense attorney was a male, very tall. And I think that he did, not badly, but I think he did pick on her a little bit, try to trick her up, because there was their defense was that she fell on a completely different part and not on this area of disrepair. And so they tried to make it seem like she had fallen. She just fell. Nothing was wrong. No area of disrepair. She just wasn't paying attention, and she fell over somewhere else. And they really stuck to the story. No, this is where this area is where I fell, in this crumbling part of the sidewalk. Huh. I fell here. This is the area where I many times asked management and the landlord to fix, and they refused to fix it. In fact, my client testified and she had evidence of it, that she offered to fix it herself. Literally had bought a bag of concrete, and her husband had offered to fill the area in because it was so unsafe for them when they were walking around and carrying things, and because she had tripped before, and they refused to let her fix it, but then refused to fix it too. Yeah. And of course, then the landlord, says he himself, the owner, he didn't know anything really about anything. But the people he had hired that were there in and out, they said, no, you can't fix it. So, some whenever I hear a situation like this, and then I hear that the person had either tripped or fallen on it before or something, some lawyers may shy away from it, because it really is, it's notice to the defense. Correct.
But it's also notice to her.
Oh, Oh, yes.
Yeah,
yes, that was not lost on me.
Right.
That was not lost on me that the evidence of the prior fall could cut both ways.
Yeah, it's a double-edged sword.
It really is. And you don't know how they're going to take it. You can explain that.
Right.
Hey, she had fallen before. It had injured herself slightly. But they both knew. So who's more responsible for it?
Right. Did you talk about that during jury selection?
I think it did come up.
Yeah.
I think it did come up that we had, there had been, a prior fall. I mean, the jury certainly knew.
Yeah.
The jury certainly knew before we started our opening that there had been a prior fall. Because I think I would have had to have brought that out so that they heard it. Because you don't ever want to shy away from a bad fact or hide it.
Right.
The worst thing that could ever happen is if you have a bad fact in your case and the first time it comes out in front of the jury is out of the defense attorney's mouth.
Yeah.
No. No, absolutely not. You got to get that. You got to get that out. It's like a child getting a bad grade and the parent finds out on the grade book rather than the kid coming home and saying it. You got to get that. You got to get ahead of it.
Yeah. Exactly.
You can't be back playing and playing.
Yeah.
Catch up on it at all.
Yeah. I mean, it's hard enough. We're in there asking. We've got our hands out saying, "Can you give our clients some money?" In your case, not so much, but obviously, that's in everyone's mind. Eventually, this woman's going to want some money.
Correct.
Yeah.
Correct.
Yeah. So, as far as another advantage of bifurcation. Costs saving,
certainly. In our judicial system, the costs are borne by the plaintiff as far as pursuing their case. And so, if you do the liability and the damages side of things, you have to present medical evidence, which in our case is testimony by a deposition beforehand that you play for the jury, or bringing a doctor or some sort of medical professional that's qualified to give testimony for the damages. And in this case, she had a pretty significant wrist fracture with surgery and had treated for it for a decent amount of time. And she had actually seen a couple different providers. And so we would have had at least one, maybe two providers. And that's a cost of, at least $10,000 just to get through the door on a case that the defense thinks you lose 9 out of 10 times.
Right.
Or maybe he fell 10 out of 10 times. I don't know. And so we saved that cost of presenting it to trial. And so, of course, that's tough because sometimes you have to take that cost. And then if you lose, then, the firm bears the cost. But even if you win, you still have to take that cost out of the case, and the client loses that money, obviously, because it went to the medical provider. In our case, luckily, once the issue of liability was decided, they settled it. Yeah. Because her injury, a fractured wrist, it was obvious. Obviously, is on the wrist she landed on. So that wasn't the issue in the case. So to spend the time and money to take the deposition of a doctor on a case where that's not at risk, we knew that if we won the case at trial at the liability stage, we knew it was likely to be resolved. Yeah.
So going back to the case, you put on some fact witnesses. You put on our client. Anyone else?
Called the landlord.
Yeah.
And essentially for the purpose of, you make a lot of money from this place. You've had it for a long time, and you personally don't do anything. Yeah. And you don't even, he actually drove, I just had to prove a couple good facts. And so for him, I just brought him on to say, you drive by this apartment complex twice a day, every day, to your other business you own that you pay attention to.
Yeah.
And you never stop. You see it. You look at it. When you drive by, you see it's there, and you never stop. You never pull in. You never even look. But 50% of your income is from this apartment complex that you don't do anything for. Wow. And so that, I put him on essentially for that. That he didn't know anything about anything, but he definitely made money off of it. We didn't get to talk about how much he made off of it, although we did talk about how much rent was and stuff. And then they had a little part-time maintenance man that came on, and then there was a lady that worked at the little office there. But that lady also worked for multiple businesses for this landlord. So she only spent part of her time working there. And so we talked a lot about that, about how she's busy doing other things too. And there were some inconsistencies between what was reported from the client to them and kind of their note taking, not really inconsistencies for my client and what she reported, but what they all said that they were going to do about it. So we had them testify. And then the client's husband, he testified too because he was there that night. Yeah. And he didn't see her fall, but they were getting ready to go camping and she had her hands full and he was on the other side of their vehicle while they were getting it packed up. And so he heard her fall and then went around and saw her on the ground. And and then he took her to the hospital. So we had him testify. So everybody was on, the client was probably on the longest, but other than that, everybody was on and off the stand. Some were 2, 3, 4 minutes. Wow. Some were, 15 minutes. So if they only have one or two things to say,
just get it out, right? And then sit down.
Yeah.
Shut up.
Exactly. And what's nice when you have those types of situations is that when your client is in the right and you believe they're in the right, and then they will have those people that will show up for them. Yeah. Some of those people, they still live there. And that's tough. But they felt like what had been done to her was wrong, and they were willing to come to trial and stand up for what was right. Yeah. And so I felt strongly that, she had, 3, 4 witnesses that were willing to take time out of their day and travel to the courthouse and come and testify to the jury about what it was like, living there and walking in that area that was so dangerous.
When you did that, it's funny listening to you explain is like watching someone put a puzzle together. Mm-hmm. And then you see the big picture, right?
Yes.
When you were doing that with those witnesses, did you get a lot of cross from defense?
I didn't get a lot of cross because the defense, and he probably, maybe we should bring him on. He probably really disagrees with his prior strategy. The defense really put his eggs in one basket that he was going to convince the jury that the client fell somewhere else. Okay. And that she didn't fall on her sidewalk area that's like kind of front porch, kind of a sidewalk, that instead she fell on her steps coming out of her front door. And so he had this huge blow up picture, like a poster board size of the front porch steps. Yeah. He's like, does this look dangerous to you? And they were like, no. And then he's like, okay, and sat down. I think because he knew that the jury would agree that the sidewalk area was in significant disrepair, right? And that somebody should have done something about it, And so he just decided that was going to be the only defense, and that's what he really focused on. So he didn't cross them very much except for on that issue. I find, generally speaking, when you bring in lay witnesses, whether it's a bifurcated trial or a full trial, that they do give these lay witnesses a good pass. They don't beat them up too badly, because I think that usually looks pretty bad to the jury. Right. Now the spouses, sometimes they get it. Oh yeah, they get it. But the friends, the additional family. A little off topic, but I one time took a case to trial, and my client, who was a young lady in her early 20s at the time of her car accident, her ex-boyfriend, who they were dating at the time and talking about getting married, came in. She had not seen him in over a year, but she said, hey, he can speak to what I have been through. And I mean, she's seeing him for the first time on the witness stand, and he came and spoke on her behalf about how much it changed her and how it changed their relationship, and that's why they didn't work out at the time. They were 22 or 23. It's not like they were married and trying to, they were dating and young. And so, I mean, the defense attorney didn't even want to touch that. Yeah. What are you going to do? This person has no dog in the fight, and he's coming to say, hey, yeah, she was really affected. Right. So, lay witnesses usually don't take it too hard by the defense attorney.
After the jury was out, well, let me ask you this. How long were they?
Well, not too long. I wanted to say it was less than an hour.
So an hour?
Yeah, probably between 30 minutes and an hour. It takes them a little while to kind of get their little binders and get their paperwork and get settled and go to the bathroom. So I would say, 30 between probably like 40 minutes and a little less than an hour.
Okay. And what was the final verdict?
They found 80% liability on the landlord and 20% liability on the client, which for us was a huge win.
Right. And so after that happened, you were able to settle the case for a lot more than what the last offer was.
A lot more. Yes. Like 25 times the last offer. The last offer was a very, what they call nuisance value, very minimal throwaway amount that they were willing to offer. And then the final settlement was definitely into the six figures, which was a fair amount for her. Mostly because the defense attorney probably at this point in time knows, why would I ever go back and try this case on damages now? I mean, you already got smacked around on the liability side. You're going to go take your risk. You thought so strongly that you were going to win the liability. So now you've got one where you're just dealing with a pretty significant injury. Yeah,
I mean, what are they going to say? She didn't break her wrist?
Yeah, there's nothing there. He lost his mojo on it.
So this after doing this kind of maybe, I don't want to say motivated you, but opened your eyes a little bit more to bifurcation. Mm-hmm. You did a presentation on this before. Did. Yeah. So some of the lawyers out there that are listening, that are practitioners that maybe have a premises case, something like that. Let's talk a little bit about some of these, why they should bifurcate.
Yeah, I was never against bifurcation. It's just sometimes hard to have the right case for it, and when you know that the damages are pretty clear, that you're not going to get a fight on that side too, because if you're going to get a fight on both sides of it, you might as well try both sides. But I think that it definitely has its benefits. I mean, obviously, shorter trial, sooner trial. Yeah. Less costly to the client. And then, I would say, we got it settled, I think, within 10 days after the verdict, So, and I do believe that if you're worried about jury bias, then you're less likely to deal with bias against your client or against you for being a money hungry plaintiff's attorney, which, we all hear about that sometimes. If we, of course, don't feel that we do that, we're over here helping clients who really, really deserve it. And we're not the ones with multi-million-dollar companies. But in the end, the jury is less likely, I believe, to have a bias against your client because you're not asking them to make money decisions. Yeah. And so if the case is truly about, a liability dispute, don't complicate it.
Right.
Don't complicate it with the money part of it. Just get the liability figured out. And, that's that. I mean, we told the jury, like, there is, there was an injury, and that's why, and that's what this case is about. But that's not for you to worry about. Yeah. It's similar. I tried an underinsured case, and the jury knew that there had been a settlement with the at fault, and that's why the at fault driver wasn't there, and we were just against the insurance company. And we said, don't you worry about how much the client has or has not received. You just decide the value of the case, and we'll figure out the math later. That's why I said we'll figure out the math behind the scenes with the judge. Don't worry about that. You just decide what the value of this case is. And so that's what the jury had to say. You just decide what the responsibility is here, and the rest will figure itself out because you don't have to worry about that. You have a limited role here, and that means because of that, you're only going to be here for one day.
Right.
Rather than 2 or 3 days if you had to decide all of it.
Right.
And so, you don't have to worry about what the injury was or how,
Yeah.
And my client had unrelated health issues, and she's like, she was walking with a walker, like a cane. She had a cane. And because she had some sciatic issues, which were completely unrelated. So who, for all they knew, these were all related. She had a wrist brace on and a cane. And so we said, don't you worry about what the injuries are. You're only here to determine who's at fault.
Yeah. I mean, it really is. I never thought about it, but by removing the damages element of the case, you're able to spend more time during jury selection, really focused on liability problems, but then also you empower the jury, and not even just empower them, but it's almost like relief for them. They're like, like they can breathe a sigh of relief. Like, oh, great, we don't have to decide how much, this injury is worth.
Yes, and how much we're going to penalize and where that money is going to come from. Is it going to affect that person's business?
Right.
Because they don't hear about the fact that there's insurance covering all. They can't talk about that. And that's like the biggest thing, especially if you have, if you potentially have a defendant in the case that the jury would feel bad for. They feel like they're going to put him in the poorhouse because they're giving a big verdict for your client. And so you just take that element out. So I feel that in a case that it's clearly about the liability.
Right.
It seems like a good case that you should focus on that. And then, why would you not want to be able to streamline your efforts to the biggest part of your case that's most disputed?
Well, Katie, thank you so much. I appreciate it.
Well, thanks for having me.
This was awesome. So thank you, everyone. Thank you for listening to another episode of Circle City Conversations. Be sure to like and subscribe.